Is attorney Alina Nuñez, and I want to thank you so much for joining us today on this webinar to discuss estate planning basics and how to best protect your family. I do want to make a little notation and let you guys know that this is a pre-recorded webinar, but if you have any questions, you can post them in the chat and someone should be monitoring the chat to be able to get back to you. Or if not, you're going to be able to click on a link that'll take you to our questions page and you can put in a request there with any questions that you have. So a little bit about myself. As I mentioned, my name is Alina Nuñez. I am the owner and founder of Nunez Estate Law and Title. Our law firm specializes in real estate transactional matters, both residential and commercial, estate planning, and probate administration. And today in the webinar, we're going to be focusing on the estate planning and going through some basics that maybe you've heard some of the words that we're going to talk about today, some of the documents, and maybe you haven't. So this is pretty much it's a great introduction, whether you've done a will before or you haven't done a will, or you've always been meaning to. It's one of those things that's always kind of on the back burner of, I know I need to get to do that, but I haven't done it because I get you. Nobody likes to talk about death, but the reality is it's better to be prepared and to avoid leaving any headaches to your children, your loved ones, once you pass away. It's already, they're already dealing with the difficult loss of someone. We don't want to add on to that with all the stress that comes along with having to do a probate administration. So without further ado, we're going to get started with our presentation today on Protect Your Family Estate Planning Basics. So thank you for joining us, and we hope that by the end of today, we can help you to create a plan to protect your family's future. One never knows what the future is going to bring, so it's very important that you are prepared. So what to expect? In this presentation, we're going to give you an overview of the estate planning process, help you identify key decisions that you need to make in order to get your estate planning done. We'll discuss how to create a plan for you and your family and your assets, and planning for any medical contingencies or any unique circumstances. Finally, we're going to also help you understand what the next steps should be. Estate planning really is very unique to each family and each situation. So it's not necessarily always about what type of assets you have or if you're a millionaire or not, but your family makeup, whether you have minor children that you have to consider, or whether you have children with special needs, or a family member that you want to leave something to, but you want to make sure that it is protected and managed by someone like in a trust, for example. So we're going to get into all of this, but when you go and speak with your estate planning attorney, hopefully myself, these are all things that you need to take into consideration. It's not just about what you own, but also what is your family dynamic, and the day that you are not here, who are you going to entrust to make those decisions and take care of those assets for your loved ones. So planning for your family, no matter what your family looks like, whether you're married, you're single, whether you're a parent or otherwise, it's very important to have a plan so that your wishes can be carried out when you pass away. So let's start by talking about the kids. So if you are a parent to a child under the age of 18, a legal guardian will be needed for any minor children in the event of your death, the death of both parents. So that is something very important to keep in mind. Even though your child might be 16 or 17, if heaven forbid something were to happen to you and you pass and your child has no more biological parents alive, you need to name who's going to be their legal guardian until they reach the age of 18. Okay. If you do not have a will that names this, or a trust that names this, or a designation of pre-need guardian, which is again a document that's naming this, you're going to leave that decision in the hands of a judge or in the hands of the court and the state. They will choose the legal guardian for your children. So can you trust the state to take into consideration all the things that you would like when choosing a guardian, such as religion preference, what type of school you would like for them to go to, what type of daily way of life you would like for them to have. That is why it's important you make that decision. So a declaration of naming a pre-need guardian for a minor will allow you to select who it is that you want to be your child's guardian in case you were to be in the situation where you have passed and you leave a child behind that's under the age of 18. So when choosing a guardian, you need to consider the following. Is this person willing to raise my children or my child? Is this person of legal adult age in your state, which is usually 18 years or older? And obviously they should preferably reside in the state where the children are. Do my children know, respect, and love this person? Because this is who's going to step into your shoes when you are not here to be their guardian. Is this person responsible and mature enough to raise my children? Is this person healthy and physically capable of taking care of my children? I know a lot of times we want to leave this to our parents, but if you find yourself in a situation where your parents are elderly, this is going to be more of a burden to them than anything else. So these are all very important things to take into consideration when naming that person. Also, does that person that you're naming share your beliefs and values? Maybe do they have the same religion or not, the same values that you do? Does this person have living space for my children? So if they're going to go live with this person, do they physically have somewhere for your child to be comfortable and live in? These are all things that you need to take into consideration. And finally, does this person live near my children's other family and friends? Because already if they've lost a loved one, a parent, you don't want to separate them from their extended family, from an aunt, an uncle, cousins, grandparents. You want to try to keep them in that same environment to minimize, any sort of trauma from already losing their parents. So these are all key considerations to take, key points to take into consideration when naming that person or those individuals to serve as guardian for any of your child until they reach the age of 18. Once they're over 18, they're considered an adult in the eyes of the law, and they won't need to have a legal guardian named for them. So even parents that might be watching this that have high school students, like myself, I have a 16-year-old, this would still apply to them because they are still considered a minor. So going back to the question of children now, do you have children with special needs? So you got to make sure to take into account what your children with special needs will require if you can't care or provide them for them because you are no longer here. So creating a detailed plan will be in the best interest of your child with special needs if you aren't here to care for them. Also, you can set up what we call is a special needs trust. And a special needs trust includes provisions designed to protect a physically or mentally disabled trust beneficiary's eligibility for need-based government benefits, such as Medicaid or what we call SSI, supplemental security income. Those are all very important to go through a trust so they don't lose those benefits. These types of trusts include restrictions on how the funds can be used so that distributions can be made to pay for items that are not protected or provided for by Medicaid or SSI. And it also provides exclusivity from government assistance programs for which they could qualify for. So they won't lose those benefits if you leave them a large amount of money in a trust. If it's set up correctly and it's done by way of a special needs trust, they would have the benefit of that money managed by a trustee, but still be able to qualify for those types of government programs and benefits. That is very important for them. So let's talk about minors and finances. So legally, a minor, again, anyone that's under the age of 18, cannot own property or assets in their individual name. So for this reason, it is essential to name a guarantee of the estate or to create a trust and have a trustee named to be able to manage those assets on behalf of your minor. This person will be responsible for managing the estate, financially providing for the children, and using the money from their inheritance until they reach the age of 18. Now we have what we call A testamentary trust. So you've heard me use the word trust and now testamentary trust. Well, what's the difference? Well, a testamentary trust is created by way of a last will and testament. So if you have specific instructions how or when your wishes are to be distributed, then you can set up a trust as part of your will. With a testamentary trust, you can stipulate specific terms for when your children or beneficiaries receive funds from an inheritance. So, for example, some parents might want to withhold distributing assets until the children reach a certain age, whether it's 25 or 21 or even 30. Or if they want to set a condition like they need to graduate from college, that all can be done by way of a trust. And this prevents assets from being distributed all at once automatically. So with a trust or a testamentary trust that's created through a will, you appoint a trustee to manage the funds until the assets will pass to the beneficiary upon that condition you set. So until they're 25 years old, everything is managed by a trustee. But once they turn 25, then they can receive the distribution directly. Um, a testamentary trust, the difference between that and a regular trust is that a testamentary trust is not created while you're alive. It's incorporated and created as part of your last will. I always suggest to my clients to create a trust while you're alive because having a trust will avoid having to go through probate, where a testamentary trust doesn't get created until that will goes through the probate process. So although it's a good option, the best option is to create a revocable living trust while you're alive and transfer your assets to that trust to avoid probate. So now let's talk about adult children. We talked about minors who are under the age of 18. Now we're talking with adult children. So even if you're a parent and you have adult children, having a will and outlining how you want your assets distributed can prevent a lot of stress and to your loved ones. Because again, a will, although it's very important, still requires to go through a whole probate process. So it's not uncommon for adult siblings to disagree on the parents' wishes once they pass away. And this can be prevented with having a detailed estate plan. So providing specific instructions regarding who you want to receive what, who you're naming as the representative or as the trustee, and how you want your assets distributed. That is the goal of having a proper estate plan in place. I like to refer to it as your instructions to the world when you are no longer here with us. So some of us have a little bit of complicated family situations. So things can get a little sticky. And that's why it's important to create, when you have a more complicated situation, to consider creating a revocable living trust. So a revocable living trust details everything from who will manage your trust, which is the trustee, to the terms of the distribution of those assets, such as not receiving it until they're 25 or until they've graduated college or whatever other condition. And that'll give the instructions on how things are supposed to be distributed. So now, one thing that I briefly mentioned, touched upon, was the word probate. And probate is the legal process required to prove that your will is authentic before assets can be distributed. So one of the benefits, as I mentioned previously, of a revocable living trust is that does not have to go through a probate process. And probate process can take anywhere from a couple of months to years, and it could be a very costly process. So that's why we always suggest the best option is to have a revocable living trust. But again, that all will depend on your situation. So when you sit down with like myself and go through your estate planning, we really put together a package tailored to your family, to your assets, to your wishes, and make sure that that's exactly how everything is set up. Okay. So what are assets? You hear this word, what are assets and everything? Well, assets are what you own here in this lifetime, whether it's a real estate, a piece of property, whether it's a boat, a car, money in a bank account or an investment account, even our clothes, our jewelry, works of art. all of that is considered our assets. So once you've considered the people in your life who will inherit your assets, the next step is to understand how do they get passed to those beneficiaries. So to start, we always ask our clients, create a list of all your assets. It could be guns, it could be paintings, anything that you own that is of value or of importance to you is your asset. So, including financial accounts, real estate, businesses. That's a big one. If you own a business or you're a shareholder of a business, all of that are considered part of your assets. Life insurance through an estate plan can be an efficient way to transfer your wealth to your beneficiary. So if you have a life insurance policy, you typically will have there named a beneficiary that will inherit that policy or receive the payout of that policy upon your passing. So life insurance, depending on the value of your policy, together with an irrevocable life insurance trust, or what we call an ILIT, can be an efficient and an effective way to leave behind what your family will lose financially with your passing. So life insurance policies and limits, when someone asks me, well, do I need to have life insurance? Or if I do, how much should I have? And there is no magic number to give. Some people, one common rule of thumb that they use is if you are like the head of your household and your family relies on your income to continue to pay that mortgage and the expenses related to your primary home, so they continue living there even though you've passed away. One rule of thumb is try to have a life insurance policy that will at least cover the amount of your mortgage. So let's say, for example, if you have a mortgage on your home, a balance that's roughly, let's say, $450,000 left to pay off, you might want to take out a life insurance policy of half a million, 500,000. That way there is enough money when you pass away that your spouse or your partner can go ahead and pay off that $450,000 mortgage and then still have $50,000 to help with the annual taxes or the insurance or whatever other expenses while they kind of reassess their new situation without having you there as part of a contributing income. So that's one suggestion I give my clients. If you find yourself in that situation where you have a mortgage, at least having a policy for the balance of your mortgage at a minimum should be it. If it's a situation where I have a little bit older clients and they don't have a mortgage, but they want to be able to leave funds for their grandchildren to go to college, well, then you can say, okay, if I have 4 grandchildren and I want them to be able to each have $100,000 to help pay for college and graduate school or whatnot, then you could take out a policy for $400,000 and you could name the trust, your trust that you set up, as the beneficiary. And that way within the trust itself will state, from this policy, 100 goes to this grandchild, 100 to this one, and break it down. And so the day that you pass away, that money will go into an account for the trust and your trustee will go ahead and distribute it to all your grandchildren. So that's how those policies work together in conjunction with a trust. And again, the goal in all of this is to avoid having to go through a probate process. And that is the best way to set it up to pass through the trust and avoid probate. So we've talked about trusts, wills, questions of when you're not here, when you pass away, things that you have to take into consideration. There are other important estate planning documents that we need to take into account while you are alive, and if any sort of emergency or situation presents itself. One of those is what we call a designation of healthcare surrogate, and that is a document that helps plan for medical issues and medical contingencies. So this will include someone that will you name that can make decision in case you become medically incapacitated, who you authorize to make medical decisions on your behalf if you cannot, who you authorize to be able to make financial decisions if you're unable to make them. What are your medical wishes? For example, if you want a do not resuscitate order, or oftentimes in conjunction with the healthcare surrogate, we do what's called a living will. And in the living will, you already leaving your desires known that if you are in a vegetative condition, a vegetative state, and it's been determined by your doctors that there is no probability of you recovering from such condition, you are letting your wishes be known that you don't want to be maintained alive artificially. These are all, again, giving you the power to make those decisions. Because if you don't have these documents, nobody has the power to make those decisions. The court will have to name someone to make those decisions. Oftentimes, it's a misconception of, well, I'm married, so doesn't my husband or doesn't my wife get to make that decision? And the answer is no. Legally, no. If there is not a document signed by you where you have selected who you want to name as your healthcare agent and to be able to make those decisions, a spouse, a child, they don't have automatic legal rights. They would have to open up a guardianship case because you're still alive and petition with the court to have the court name them to then be able to make those decisions on your behalf. And oftentimes we don't have the luxury of time for this, and it is quite honestly an expensive process. So, and it's time consuming. So if you have your documents in order, you have your designation of healthcare surrogate where you're naming your spouse to make the decision. If your spouse can't make the decision, then you name your child as the alternate, or if you have multiple children, you can name them in order of succession if you want, or you can name two together to make decisions as co-agents. But the idea is that you are the one making that decision and leaving it known in writing that this is who you want to give that authority to. Another important document is what we call a power of attorney. So another thing to consider is who's going to make financial decisions if you become disabled or incapacitated. If you are caring for a parent that develops dementia or Alzheimer's, it is extremely important to have all of these documents, because once they are too far advanced with the dementia or Alzheimer's, they cannot legally sign those documents because they don't have the mental capacity to do so. So as part of your estate planning, you can name a power of attorney. As I mentioned, the healthcare power of attorney or a general durable power of attorney who can make decisions on your behalf. So designating someone to make these decisions can provide relief to your family members who don't want to take on that responsibility. Maybe one of your family members is like, no, this is too much responsibility for me. I don't hold up under pressure. So then you might want to name someone else. As parents, we all know, maybe you have a child that's in the health industry. Maybe they're a doctor or a nurse. That's going to probably be the one that you're going to want to name in your healthcare power of attorney. But maybe your other child might be a director of finance or involved in business. Well, maybe you want to name them in your regular durable power of attorney to be able to handle all of your financial matters. So this is where it really takes you to sit down and think about these things and think about these factors when making this decision of who you're going to name as your agent to serve in these different capacities, to make healthcare decisions on your behalf, to make banking or any other type of decisions on your behalf. So the financial power of attorney also can help pay, the person who's going to take care of paying bills if you can't, make investment decisions, and handle all other financial matters on your behalf. So these are all very important things to take into consideration of who would be the ideal individuals to serve in these different roles. And one other thing I want to mention real quick is once you do these documents, they go into effect and they're good until the day you pass. But you can always change them. as I tell my clients, these are not written in stone. You do them today, and from now until the day you pass away, things change in your life. Maybe the person you named, you might not have a relationship with them anymore, or maybe that person passed away. You can always change these documents as needed. So just want to mention that real quick and keep that in mind. So what about an executor? So you're going to have to name an executor for your will and a trustee for your trust. When you pass away, that executor or trustee is the person who can perform the legal tasks that were your responsibility regarding your estate. So they would be the ones to hire the attorney, open the probate if it's necessary with the probate court, take care of handling the distributions of the assets of the trust. So these are all the types of responsibilities: paying your creditors, reviewing medical records, or distributing your assets to the beneficiaries. This is the individual that you are going to name to make those decisions on your behalf. So who do you trust? The executor of your will and the trustee of your trust have a very, very important role. So you want to carefully consider who you're going to name as the executor or the trustee. The person should be someone who can act responsibly on your behalf, who can communicate with your beneficiaries. You can name anyone as the executor of your will so long as they're an adult over 18 years of age. If you don't trust friends or family members for this important job, you can name an attorney, an accountant. There are companies that serve as trusts, as trustees and as executors. Obviously, in hiring third parties like that come certain fees associated with that service that would get paid out of the trust assets. So you need to name at least a successor, you need to name at least a trustee or an executor. And we advise our clients to name at least one additional younger, healthy successor or executor in the event that you don't update your will. So there's a chance. So if you want to name, let's say, a parent of yours as a trustee, because obviously you trust them, but if they're already older in age, chances are you find yourself where they might have passed away. And if you did not update your trust documents saying who the alternate is, now we go back to, again, well, the court then has to decide. So I always tell my clients, give me your first choice and give me at least one alternate. I have had clients that have, let's say, 3 children, so they don't want to offend or hurt any of their children's feelings. So they will name either in order of birth order, oldest to youngest, but they'll name this child first. If not, then the second. If not, then the third. And you can absolutely do that. There's no kind of limit as to how many alternate trustees or executors you can name. You could also name 2 people to serve together. That one I always try to shy away from, because then these are 2 people that have to make decisions together. But it's definitely an option. Again, this is all depending on what your family dynamic is and what your wishes are. I'm not here to tell you, no, you should not name your 2 children as co-trustees. You know your children better than I do. But these are all important things to take into consideration. So location. So when naming someone who's going to be a trustee or be a personal representative, they don't typically have to be located in the same city where you are. It would help, especially if you're dealing with a situation where you have a property and someone needs to go and clean out that property. They need to take an inventory of all of your personal assets, furniture, jewelry, personal effects, all of that. So it does help to have some, but they could always fly in, take care of all of those things, and then go back to where they live. And if a process needs to be done with an attorney for the distribution of the assets through the trust, or if a probate needs to be opened up for an estate, that all can be done even though the executor or the trustee does not live locally. Personally, I have had probate cases where my trustee lived in Argentina. I had another one where all the beneficiaries lived in Spain. Within the US, I've had them in all sorts of different states. But at one point or another, for the most part, they will come in to town to take care of gathering the assets, doing the inventory, so that we can then go ahead and do the distribution. But they don't necessarily have to live here in town for you to name them, but they do have to be at least 18 years of age or older. So where do we start? We've talked a lot about the process of doing your estate planning, and I know it's a little probably overwhelming, and you've heard a lot of terms, you've got a lot of information. So, okay, Alina, I'm ready to start. What do I do? Well, my first suggestion is obviously contact our office. We can schedule you for a consultation. We'll send you our intake form. But in the meantime, while you do that, start getting together your documents. Start getting an idea, start writing down a list. What type of bank accounts do you have? What type of investment accounts do you have? Do you have an IRA, a 401k, a money market? Do you have funds in a CD? Do you have a life insurance policy? Just start kind of making a quick inventory of all of that, as well as your personal assets. Is there something that you specifically want to leave to one of your beneficiaries? Is there a certain watch you want to leave your daughter? Or is there a certain painting you want to leave your son? Or, I've had clients that were retired police officers and had a collection of handguns, and they wanted to leave certain handguns to certain children. All of that, you can sit down and make a list and get an idea of who you want to leave what assets to, as well as put together a list of any of the real properties that you own, whether it's the house you reside in, any investment properties, vacant land. Start jotting all of those down. And then, very important, start thinking about who are you going to name to make all of these decisions on your behalf. If you have minor children, who do you want to be their guardian? If you have a child with special needs as well, and what provisions do you want to make for them in that trust? If you have elderly parents, or if you have anybody that want to leave something to, or that you want to make decisions on your behalf, make your medical decisions, your regular day-to-day life decisions in case you can no longer make them, start considering who you would name to fill those specific roles. And once you have that, then we can sit down, schedule you for a consultation, and as I mentioned, really kind of go through and create a plan that is special and unique to you and your family and your circumstances, depending on everything that we've kind of discussed here. So remember that creating your will is only the first step. It's your responsibility to keep your wishes up to date as your circumstances change. Like I mentioned, these are not written in stone. I always suggest to my clients the important times in which to review your estate planning is if there is a birth. So for example, if you did your will and you had no children, then 2 years later you had a child, that is a great time to update your will or your trust to include that child. If there was a divorce, let's get that X out of those documents. If you got married, well, then now we have to take into consideration your new spouse. And if there is a death, someone that maybe you named as an executor in your documents or as a beneficiary, if they passed away, we now need to then remove them from those documents. So during all of those major life event changes is a wonderful time to review your estate planning documents. So if you don't want, let's say, for example, you don't want to be a parent to create a will that provides for your firstborn, but leaves nothing for your younger children because your will wasn't updated by the time that they were born. So those are all wonderful examples of when you need to update your documents. I'll keep in mind also who you need as the legal guardians. If they experience any life changes that might cause you to reconsider naming them, such as maybe they moved out of state, you'll want to change those documents to update that. Very important. I know it's so tempting nowadays. We can all jump on Google and go on Google and say, okay, give me a will, or I need a power of attorney. I plead with you, please do not leave your estate planning to Google. Work with an experienced attorney to ensure that your wishes are properly and legally filed. There are many, many details that must be handled in order to create valid legal documents. Too many individuals make the mistake of creating these documents online, trying to fill them in. They're filled in incorrectly. They're missing important signatures. And then what you're going to do is you're going to leave a headache for your loved ones and force them to have to go through a legal court process of probate to be able to distribute all your assets. And not only that, but if you did it incorrectly and you decided that you wanted all your assets to go to one person and it turns out that the will wasn't done validly, it could definitely turn out that your assets go distributed to someone else that maybe you didn't want to inherit. So it's very important. I tell people leave Google for like restaurant reviews or finding out what's there to do around me on a Saturday night. But please don't leave it for your estate planning. This is very important, too important to leave it to just try to do it yourself. Sit down with an experienced estate planning attorney as ourselves. We have packages and prices for every different type of situation. Again, it's very custom to your dynamics, but trust me, we can help you and set everything correctly to give you peace of mind and know that there's nothing left, that it wasn't done the way that you wanted it done when you are no longer here with us. So that concludes our time together today. If you have any questions, as I mentioned, put them in the chat. We have someone that should be monitoring the chat, even though this was already a recorded webinar. If not, you'll be able to click and be able to submit a question through like a request page, and we will get back to you, as well as if you would like to schedule a consultation or an appointment, we would be happy to do so. Here is all of our office information. Follow us on Instagram and on Facebook. I put out a lot of content, a lot of videos that answer a lot of sometimes basic questions and very informative. I've had clients tell me that they love our videos, that they check out our YouTube channel, and that they've learned a lot. And I talk about all of our practice areas: real estate, estate planning, and probate administration. There is our office number where if you can call to make an appointment. And anybody that watches this webinar, please let our intake person know, and we normally charge a $200 consultation fee. But for anyone that is attending this webinar, I will be waiving that consultation fee. So when you go call our office to make your appointment for the consultation, just let the intake person know that you attended our webinar and that consultation fee will be waived. So there you go. I'm giving you a $200 gift, a $200 incentive to call us and get your estate planning done. As I mentioned, I know this is not the best topic. People usually don't like talking about this because it's some serious heavy stuff, but it also should give you peace of mind once you're done. And it should really kind of take a load off your shoulders and know that your estate planning is done in order. Everything is done to your wishes and how you want it done. And you're not going to leave any headaches or turmoils behind for your children or your other loved ones. So again, thank you very much for tuning in today, for checking out our webinar. We're going to be doing more of these in the future on different topics. So again, another reason to follow us on social media so you can stay informed of when these next webinars will be. If you found this useful, if you found it informative, I hope so. Please feel free to give us a call so we can help you with your estate planning. And in the meantime, again, I say thank you. My name is Alina Nuñez, owner and founder of Nunez Estate Law, and we are here to help you protect your greatest assets for future generations. Thank you very much, everyone, and I hope you've enjoyed it, and take care.